Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Quotes This Week on LiveLaw, where we update you about all the important legal developments that took place across the country last week. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, please do support us by liking and subscribing to our YouTube channel. Let's begin. The Supreme Court of India has prohibited the two-finger test in rape cases and has warned that persons conducting such tests will be held guilty of misconduct. It is regrettable that two-finger test continues to be conducted even today. A bench comprising Justices D.Y. Chandrachud and Hema Kohli lamented while restoring the conviction in a rape case. While dictating the judgment in open court, the Supreme Court bench also underscored that the Supreme Court has time and again deprecated the use of two-finger test in cases alleging rape and sexual assault, and that this so-called test has no scientific basis whatsoever. The Supreme Court bench comprising Chief Justice U.U. Lalit, Justices Ravinder Bhatt and Bela M. Trivedi granted relief to Arun Puri, founder-director of India Today, in a defamation suit. The petition was filed by Arun Puri challenging the criminal defamation complaint filed over a 2007 news article titled Mission Misconduct in India Today magazine. However, the court did not grant relief to the author of this particular news article. Pronouncing the verdict, the Supreme Court bench said that it has allowed the appeal of Puri. The news article in question reported about the allegations against the then Indian Deputy Consul General in Edinburgh, O.P. Bhola. The Supreme Court of India has set aside a Madras High Court judgment which quashed PMLA proceedings initiated against a bribe giver. A bench of CJI U.U. Lalit and Justice Bela M. Trivedi observed in the judgment that by handing over money with the intent of giving bribe, such a person will be assisting or will knowingly be a party to an activity connected with the proceeds of crime. Without such active participation on the part of the person concerned, the money would not assume the character of being proceeds of crime, and thus the relevant expressions from Section 3 of the PMLA Act are thus wide enough to cover the role played by such person, the verdict stipulated further. The Supreme Court has commenced hearing on the issue as to whether striking down of a provision granting immunity from arrest would have retrospective application, especially in view of the rights protected under Article 20 of the Constitution of India. A 5-judge bench of Justices S.K. Kaul, Sanjeev Khanna, A.S. Oka, Vikram Nath and J.K. Maheshwari was hearing the matter. Earlier, Solicitor General Tushar Mehta for the Union of India had stated that once a provision is struck down, it would be considered as if the provision never existed. The Supreme Court of India has affirmed the death penalty awarded to Lashkar-e-Taiba militant Muhammad Arif for the 2000 Red Fort attack case, which resulted in the death of 3 persons, including 2 army officers. The Supreme Court of India dismissed the review petition filed by him, challenging his conviction as well as the sentence imposed upon him. A bench comprising CJI U.U. Lalit and Justice Bela M. Trivedi has stated while pronouncing the judgment in open court, and I quote here, "We have accepted the press that electronic records must be eschewed from consideration. However, having regard to the entirety of the matter, the guilt is proved. We affirm the view taken by this court and reject the review petition." The Supreme Court has observed that mere non-supply of documents to delinquent employee cannot be a ground to set aside disciplinary proceedings. Mere non-supply of the documents, which may not have resulted in any prejudice caused to the employee, the order passed by the disciplinary authority cannot be set aside, the bench of Justices M.R. Shah and Krishna Murari has observed. In a crucial judgment delivered, the Supreme Court of India has upheld the provisions of the Employees' Pension Amendment Scheme of 2014 and has set aside a judgment of the Kerala High Court which had quashed this particular scheme. However, so far as the present members of the fund are concerned, a bench of Chief Justice of India U.U. Lalit and Justices Anuradha Bose and Sudhanshu Dhulia has read down certain provisions of this scheme. Importantly, in a relief to several employees, the Supreme Court has also held that employees who have not exercised the option to join the employees' pension scheme must be given a further chance of 6 months to do so. The Supreme Court of India has directed the transfer of all the first information reports lodged against Naveen Kumar Jindal, former media head of the Bharatiya Janata Party's Delhi unit, for his remarks made against Prophet Muhammad to the Intelligence Fusion and Strategic Operations, that is the IFOC unit of the Delhi Police, which is a specialized team constituted to prevent cybercrimes, online abuse and communal disharmony. Apart from that, a direction has also been issued specifying the lead case in the investigation. The court has also granted Jindal protection against coercive action for a period of 8 weeks to enable him to approach the Delhi High Court for appropriate relief. The Supreme Court of India has lifted the stay which the Uttarakhand High Court had imposed on the government order which provided 30% reservation to the women domiciled in the state of Uttarakhand in state services. A bench of Justice S. Nabdul Nazir and Justice V. Ramasubramaniam also issued notice to the respondent seeking a reply on the special leave petition filed by the state of Uttarakhand. The state filed a plea assailing the interim order passed by the division bench of the High Court, staying the 2006 order of the state government. The High Court had stayed this particular government order on the prima facie view that the government order was contrary to the mandate of Article 16, Clause 2 of the Constitution of India. The Lucknow Sessions Court has rejected the bail plea filed by Kerala journalist Siddiqui Kappan in connection with the Prevention of Money Laundering Act, that is a PMLA case initiated against him by the Enforcement Directorate. The order in this case was reserved earlier this month by the concerned district judge after concluding the hearing in the matter. The rejection of his bail plea would essentially mean that he would continue to remain in jail despite being granted bail by the Supreme Court in other cases back in September. The Kerala High Court has said that Islamic clergy who have no legal training or knowledge in legal sciences cannot be relied upon by the court to decide on a point of law relating to the personal law applicable to the Muslim community. Ordinary scholars and the Islamic clergy who have no formal legal training find it difficult to deduce Islamic law from its sources, said a division bench consisting of Justice A. Muhammad Mustaq and Justice C.S. Diaz, while dismissing a revision petition challenging its decision on the interpretation of Khulla. The Kerala High Court has set aside the order for transfer of Kozhikode Principal District and Sessions Judge S. Krishna Kumar, who made the controversial sexually provocative dress remark in the Civic Chandran's case. A division bench consisting of Justice A.K. Jayasankaran Nambiar and Justice Muhammad Niaz CP allowed the judicial officer's writ appeal and quashed the order of the Registrar General transferring him to the post of the presiding officer of Labour Court, Kollam. The Madras High Court has criticized the recent trend of parents implicating school authorities and teachers whenever a school student dies by suicide. Justice S.M. Subramaniam noted that teachers and headmasters could be made liable only if there was sufficient evidence regarding their proposed misconduct. The court also noted that while it is easier to engage in blame game, it is much more difficult to maintain discipline in schools. Furthermore, such general blaming would also negatively affect the students studying in the institution, the High Court stated further. Thank you. Keep watching Courts This Week on LiveLaw for more such updates. See you next week.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.